And I welcome everybody to our third and last day of the first workshop on hate speech, interdisciplinary approach international webinar. Our first session today will be headed by Hadil Abu Hussein. Hadil is a postdoc fellow at the Minerva Center for the Rule of Law under Extreme Conditions, and she will moderate the first session by Asaf Deri and Efrat Fudam. And so, Hadil, the screen is yours.
Thank you, Michal. Good morning, everyone. Thanks for the very interesting presentations and the workshop the past 2 days, and looking forward to today's discussion as well. It's my great pleasure to introduce Efrat and Asaf for today's presentation of their paper. Some of them want to abuse you, readjusting defamation law to combat hate speech abuses of freedom of speech. Efrat is a lawyer and social activist in Israel. She serves as lecturer and legal clinic instructor at the Stricts Faculty of Law, College of Management. Efrat holds LLB in Law and Political Science from Bar Ilan University, and LLM with emphasis on Human Rights and International Law from Emile Zola Center College. Her areas of research are legal violence, law and culture, law and gender, and libel laws. Asaf Deri, he is a PhD candidate on the Faculty of Law, University of Haifa, and lecturer and legal clinic instructor at the Stricts Faculty of Law, College of Management. Deri holds LLM from the American University at Washington, D.C., and MA in Literature from Tel Aviv University. Please, the floor is yours, Asaf and Efrat.
Thank you. Good morning, and thank you for the opportunity to present here after 2 days of fascinating lectures. They have contributed a lot to the continuation of our work on our draft document. Our motivation to write comes from our day-to-day experiences working as lawyers in legal clinics and dealing with thousands of defamation lawsuits, especially in the past year, following postings on social media. Defamation laws that were previously reserved for media publications are now a tool for citing public criticism on social networks. During the past year, we have and continue to represent clients in over 30 legal actions. We have become the main center for protecting individuals' freedom of expression against slap lawsuits. Citizens engage in political protest, seeking to express their opinions about the police and other government authorities, women looking to expose sexual harassment, or seeking protection against violent partners, leaders of the protest of Ethiopian immigrants, key anti-government protest activists, a prominent feminist website, a well-known artist and musician, and a social radio broadcaster. All of them, we have served as a voice and as protectors. We fight to prevent their voices from being silenced by lawsuits and intimidation. Today, we have been successful in all of the cases that have been decided upon. Because we are involved in the academic world and in the field, we are forced to talk through and understand a lot of these new types of claims and the conceptual difficulties that come with them. The main difficulty we would like to present in today's discussions and paper is the conflict between freedom of expression and hate speech. Most of the public debate today is conducted on social media networks. Private citizens, media channels, public figures, and heads of states have found that quickest and easiest way to convey messages to the masses is through social media. The transition to this channel of dialogue has caused a revolution worldwide, and as in any revolution, the rules of the game and debate are taking shape on the fly. At the touch of the keyboard, protests are started, corruption exposed, governments elected or outed, all above all, a variety of voices are heard, many of which have never enjoyed public exposure before. What sets social media apart is the fact that anyone with a keyboard and a basic network connection can convey messages without censorship, even without the barriers and limitations of social and economic status. Therefore, the statements are often not couched in sophisticated language and philosophical or poetic expression, but often take the form of angry posts, sometimes unpolished and even sloppy, seasoned with juicy vulgarity. This popular social media tool has created a new language with its own laws. Oftentimes, the expressions we are required to protect are the expressions we seek to protect society from, expressions that can be racist, anti-Semitic, or just plain rude. As human rights lawyers, we often ask ourselves, is it right to represent expression we dislike? As a feminist who defends women, is it right for me to represent a man who writes against women? The great difficulty we face is that the courts only examine what we say as required by law. They don't ask who said what, against whom. And the case of police lawsuit illustrated this difficulty well. Now we want to show you from a short video.
איך קוראים לך, בחור? שיילי. עוצרים אזרח פה בכוח. סולקים אותו. סולקים אזרח בכוח. אנדרי, השוטר, מאבד את זה ביג טיים.
יואו, אתה לא נורמלי! אנחנו כולנו ראינו פה, הוא לא עושה כלום! תעזבו אותו!
תבין את היד השנייה! עזב אותי! אתה לא, אין לך זכות להשתמש עליי בכוח! לא, אני לא מבין אותך.
וואי, אני פשוט בהלם.
בהלם.
In the past year, dozens of liable lawsuits have been filed by police officers against civilians who criticize them on social media, usually following a video documenting unusual, often violent behavior of the police officers. Because the scenes are usually available for direct observation in the videos themselves, debate in these cases revolves around the opinions of those who respond. Following the common and accepted practice on social media, respondents do not conduct scholarly academic analysis of the event, but rather bang out a sharp response on the keyboard in a single word or sentences, flavored with spicy emojis. And so, criticized policemen, supported by generous public funding, have flooded the courts with liable lawsuits for large sums. As a result, individuals driven out of anger and apparently without much thought who type Nazi or criminal, for example, then find themselves sued for tens of thousands of shekels. Recent data shows more than 150 police lawsuits against civilians were filed in 2020 alone, and the lawsuits are still piling up. The economic model that the police plaintiffs follow is based on a combination of police support in filing lawsuits and the provision of funding for the purpose. There is also an assumption most defendants will panic and pay up immediately after receiving the warning letter, even before the lawsuit has been filed and before the matter is litigated in court. Indeed, until our intervention, most of the proceedings ended in unfortunate compromises. Many citizens had to pay out large sums for statements that often did not amount to libel, and in cases where they had excellent defendants but were afraid of becoming involved in legal proceedings and were worried of the associated risks and costs. In addition to the many cases in which we have represented defendants from the beginning of the proceedings, we are currently involved in several cases in which summary judgments were rendered in favor of violent police officers before the defendants were even be able to obtain representation. The violent video we just saw was spread on social media and got a ton of harsh reactions, some about the policeman's country of origin, some against his violent past, and some against the police not punishing him. The policeman was not prosecuted for his behavior, but rather he sued the person who filmed the video and those who commented on it on social media. However, it is important to emphasize that police officers are not the only ones who file libel lawsuits. They are also used by commercial campaigns seeking to silence consumer criticism. They are used to intimidate women trying to expose violence and sexual assault, or to seek compensation. They are used to intimidate social activists who want to express their struggles, such as the protest of Ethiopian immigrants, the land protest in Kibbutz Nir David, and more. Gradually, but quickly, libel lawsuits have become a tool that naturalizes and strips the right to freedom of expression, sending a message that any response or expression of opinion can become a financial burden. Therefore, silence may be better.
Thank you, Efrat, and good morning, everyone. Okay, like Efrat said, this study comes from deliberations that we had when we acted for people in court as lawyers, as litigators, and more than once we asked ourselves for the justification. And when is the intervention of the law justified and when isn't it? And we believe, I must say at first, that we believe that more often than not, the law should refrain from intervening, even when harsh hate speech is involved. And I hope you'll bear with me for a while as I play the devil's advocate and make a short case for hate speech. And I'll try to make it through one of the cases that we had in which we acted for a guy that published something which was unmistakably hate speech.
Asaf, do you want to share the slides? Because we can do the slides if you want. Just
maybe I'll get to that later. I prefer to speak to the slides for a while.
Yes.
So this guy, he published it was a comment on the original post that was shared on Facebook wasn't his. It was of a guy that suffered from what he saw as a strict enforcement by the police of COVID regulations. And the police came to this guy. There was a female police officer and a male police officer who came to his business place, and they wanted to shut it down because of, they said it was operating in breach of COVID regulations. And he uploaded this video on Facebook, and then some people reacted, and one of them was the defendant that we acted for, and he made a very nasty comment, a very misogynist comment about the female officer. He said that she was looking for. He thought it was funny to say that she was looking for the nearest sex shop that was around, and when she couldn't find it, then she was. Then she wanted to act. She was frustrated, and so she wanted to, I don't know, act against the people that had businesses around there. So this woman police officer, she filed a lawsuit, a defamation lawsuit against this guy, and we acted for him. And I think that. Maybe, you can say that secretly, perhaps we wished that, the court would find against him. I suspect that maybe Efrat wanted this to happen more than I did. But nevertheless, we acted for him. And we asked ourselves, what was, like Efrat said, what was the justification for us as human rights lawyers, as feminists, to act for a guy that made such a publication? And I think that, what we were defending was that, basically what happened there was that it was his way, it was this guy's way of protesting against what he saw as unjustified police activity, as unjustified harsh enforcement of COVID regulations, and it was his way of protesting, not mine, not some learned judge's way, but his way, such as it was, very crude, very I don't know, unsophisticated and eventually misogynist. And the fact that the reason why we saw it fit to defend this guy was that it was his, when we were defending him, we were defending basically spontaneity, the right to be spontaneous. And I think that I ran into a piece by Karl Čapek, the famous Czech writer, yesterday, who wrote about a dystopic scenario in which robots took over the planet, and they had like a conversation with the guy that gave them the rise to power, and they were asking him to give them the ultimate key to rule the world, and they told him, you should teach us how to procreate, because that's the essence of being human, and that's the way that we can complete our takeover of the planet. And you know, it went on like that. And I think that it's a beautiful piece, but I think that eventually Karl Čapek was he was wrong about that, because the essence of being human, I think, is not procreation. Robots can procreate if you know to I don't know, if you know to operate them well, but the thing that distinguishes us as humans is spontaneity, and that's what we wanted to defend. We wanted to defend the spontaneous expression, even if it's ugly, even if it's rude, even if even if it's racist or misogynist, and we thought that was worthwhile to make this case in court, and I'll tell you later what was decided eventually. So when does the law when is the law justified in intervening in hate speech? When do the courts should find against people who disseminate hate speech? Well, we believe that the answer for that, the short answer, is when it's not spontaneous, and that's how we came up with this, with our idea of the parallelogram model. We think that when hate speech is not a spontaneous reaction of someone who wants to criticize or to just express his opinion, but rather a part of a campaign made by an organized group as part of its hate agenda, and especially when it's directed at an individual. We believe that these are the places, these are precisely the places where the court should intervene. I want to share with you, we wrote quite a lot in our draft about an activist, a certain hate activist named Shefi Paz from southern Tel Aviv. She's an activist against refugees and asylum seekers in Israel. And I want to just, show you an example of her expressions on social media. Let's see, I have it here. Well, that's the original post in Hebrew, and that's, well, also in Hebrew, but I'll translate it for you. That's what Shefi Paz tweeted. She shared an article, a newspaper article, about the difficulties that the asylum seekers are facing in this period of the crisis of the COVID crisis. And what she said was, someone wrote that you can't expel them, and she wrote, yes, you can expel them, you just need to change the way you think. We don't need people whose favorite pastime is street fights and stabbing people, and their model of education is to have as many children as you can and then abandon them to volunteers. That's what she wrote, and as you can see, it's accompanied by a picture of specific for women asylum seekers, and according to Israeli law, that's defamation, because when you say about people that their favorite pastime is stabbing and fighting and street fighting and then abandoning the children, and you accompany that by a picture of specific people, that's defamation, because you say that about them. And so And so right now there's a lawsuit going on against Shefy Paz, filed by these 4 women for defamation. And we believe that when hate speech is made on behalf of an activist who's working as part of an organized group, who is a member of an organized group, then it's not a spontaneous expression of his or her mind, but rather a part of an organized campaign. And then, if that's the case, then you have to answer for it, especially if your hate speech is directed at a specific individual rather than an opposing group, let's say, or an activist of an opposing group, because I think it's justified for many reasons. I will not specify all of them in this presentation, but I'll just say that it's justified among other things, because when you're speaking as an activist against another activist from an opposing group, then he or she can answer you, and they have and they possess power and political power and economic power, which is equivalent to what you have, and then it's a fair fight, so to say. And under these circumstances, the court should refrain from intervening, or if they do intervene, they should award the plaintiff with to a lesser degree, with diminished compensation, as opposed to the case when which I just showed, that Shefy Paz directed her hate speech against 4 individuals who are not a part of a group, in which the compensation should be larger. So to sum it up, I think that what we propose in this model, in this parallelogram model, we propose that the courts should look not only into the content of the hate speech itself. Of course, they do have to, they should do that also, but as Efrat said before, they should also look into who is the hate speech disseminator, and also who the hate speech is directed at, who is the victim, so to say, of the hate speech expression or statement, and they should, in proper cases, not allow a defamation lawsuit to proceed if it's made by, let's say, someone. I mean, the classical case is like the one that Efrat shared before, the police officer who was depicted in the video abusing a civilian and then suing other civilians who reacted on social media. In such cases, we believe the lawsuit should not be allowed to proceed beyond initial stages, and it should be struck out and set aside at the very beginning, because the plaintiff is a part of an organized group, in this case an institutional organized group, namely the police, and as such he possesses a lot of power, and he should be expected to suffer, so to say, criticism, political criticism for his acts or her acts. As opposed to the other extreme end would be the case of Shefy Paz and the asylum seekers. And so we believe that this model will separate justly the cases that merit intervention as opposed to those who do not. Thank you.
Thank you very much, Efrat and Asaf. A very fascinating topic and paper. Actually, I really enjoyed reading the draft. Still, I agree with, firstly, you didn't tell us what happened with the case in regard of the COVID. Yeah, can you just
Right. Yes, I wanted to save this for last, and then I forgot about it. So yes, we lost this case. The court found against us. The judge. It was actually very interesting because the judge. We told the judge that, strictly speaking, this was not defamation because it was just like, it was an ugly misogynist expression, but it's not defamation because nobody, no reasonable reader, for that matter, would actually think that this female police officer was looking for a sex shop or something of the sort. So we said that according to the reasonable reader test, it doesn't qualify as defamation. But the judge told us, yes, but it's sexual harassment nevertheless. And then, if the lawsuit would have been filed as a sexual harassment civilian torts claim, then I would decide for the police officer, and that's what he did eventually. So yes, for those of you who identify with the police officer more than with the commentator, then yeah, you should be happy because we lost this case.
Thank you. Okay, Van Aken have a question. Please go ahead.
Thank you, and thanks a lot for the presentation. That was interesting. I have two questions. So the last one now coming from your answer to Adel. What is reasonable? And I wonder whether that is changing. And I remember there is this wonderful little book of Guido Calabresi who talks about the reasonable, whoever. The reasonable in common law is the middle-aged white man, Brit, who is mowing his grass on Saturdays. And I wonder whether reasonableness, as we have understood it for so long, is adequate in times of social media and the times we are living currently. So that's one question. The other question is the organized group. I do understand your arguments, but I'm wondering whether, again, social media does not change the argument in the sense that the social media give rise to what Hayek would have called a spontaneous order, like the price mechanism. So it's decentralized, individualized, but as a whole, it is somehow organized. And it can be as powerful when people retweet as an organized group. So I wonder whether this should really be the criterion to distinguish whether we talk about defamation or not. And one more thing, and I think that is more common on the whole workshop. When we try to see how we deal with hate speech, as lawyers, I feel this is deficient if we haven't really understood psychological and socio-psychological mechanisms of how hate speech gets diffused. We are unable to make a good suggestion on how to regulate it. We need to understand the real world, the psychological mechanisms who create the phenomena we are dealing with. So we need to understand the scope conditions, the variables leading to it, because after all, we are interested in protecting people and protecting social order. And unless we haven't understood this from a social science or psychological perspective, I feel as lawyers, we are somehow walking in the dark. So you don't need to answer that one. That's more general comment.
Yeah, I really, it's a good thing because I wouldn't know how to answer to that. Yeah, I'll stick to what I know, I think. Yeah, and about what you said about reasonableness, I agree, and yes, this quote by Calabresi is I think it's much in place here, but I think that I don't know. I think that Efrat will agree with me when I say that we're witnessing a mind change among judges who ultimately they have to play, whether they like it or not, the role of the reasonable person, let's say. So, like I said, I think that the example that we just gave with the guy that was sued by the female police officer, I think it was interesting because the judge was a guy. He was a male. It was a male judge, and he could identify, even though the female police officer did not frame or phrase her a statement of claim as a sexual harassment case, he did that for her, and I think that says a lot about the way that how much we advanced as a society in those terms. So I think that, you know, there isn't a ready-made, there isn't an easy solution for that problem of reasonableness, but I think that our benchmark should be, and at least I think that mine and Efat is, that we are here to defend freedom of expression, first and foremost. And so we are willing to tolerate almost any type of expression, as ugly and extreme and racist or whatever that it would be, as long as it's not actually, it doesn't represent an imminent danger of violence or you know, disturbing law and order, so to say. So I think that in that sense, and I'm trying to come here to your second question, I think that in that sense, the model that we are proposing, the element of our organization plays a key role, because what it does is it evaluates the amount of danger that is to be expected from the person that made the hate speech expression, that published the hate speech expression. I think that when we think about the individual that's commenting on Facebook or Twitter, or so to say, and it's just, you know, his or her state of mind, we can disregard that, we can ignore that. And it's the costs and the dangers are not great, as opposed to, let's say, someone like Shafi Paz, who is leading an organized campaign against a population of immigrants or refugees or asylum seekers who are socially in an underdog position. And then we can see the risk of other people following her. And then it's justified, I think, that the court should adopt a harsher position or stance against her. Right.
Thank you. But we need also to bear in mind law and order for whom, because also minority groups might not be like the system not representing that in a way or another. So it will be more, I will be more careful while using kind of this very general, observation. Okay, Elena has one question.
Hi, thank you very much for your presentation. Really interesting. Mine is more a comment and suggestion rather than a question per se. Really like the take you're presenting, although I'm not fully convinced, like defamation and hate speech. I mean, like when I first read your paper, I was thinking, yeah, but is there any risks associated with kind of like overlapping too much the defamation part and the hate speech one? I still haven't made my mind where that's something like going on. But I just want to suggest you, I know your focus is on Israeli legal framework, but I do think that you could really take a lot of good inspiration and like to support your arguments if you make reference to the case law of the European Court of Human Rights that on defamation has said a lot, especially on what you're actually proposing on the taking into consideration the the content, the perpetrator, who made a speech, who's the subject of the defamatory speech, and especially there are a lot of cases that specifically concern police officers. So you may want to look at them and to use that as support your argument, as well as maybe using the Rabat plan of action, since you're linking to the hate speech, and the threshold test in the Rabat plan of action specifically has as elements the speaker and the context and the even when we talk about the intent. So I believe you can make a lot of parallels with your proposed model and to make it even stronger. So just suggesting, but really good paper. Thank you.
Thank you. Thank you for that, Elena. You made it as a comment, so I don't have to reply, but I do have to clarify, because you were wondering about, the connection between defamation and hate speech, which is not, self-evident. I should say that, yes, it has to do with the Israeli specific framework that we're working with, because a recent, relatively recent amendment to the defamation law in Israel made it possible for people to sue following a racist or misogynist slander, and it was put under this category of defamation, and I totally agree that it's not it's not self-evident, and I guess it's not like that everywhere in the world, but here it is.
Thank you. Rutter, please.
Yes, I have two comments. One comment regards your statement that hate speech falls under the freedom of expression as long as there is no imminent danger. I know definitions of hate speech that see it a lot like you. For example, Michel Friedman in the 90s and early 2000s formulated a definition of hate speech that was very much focused on the danger for actual real-world physical violence resulting from hate speech. However, in more recent decades, there seems to be a shift towards definitions that stress the emotional and psychological damage inflicted upon the victims of hate speech. And perhaps you could try and address those concerns, even if you do not share them and believe that the right to free expression still trumps the protection of minorities. But I believe as this strain of thought has become so dominant in hate speech discourse and hate speech definitions, it should perhaps be addressed. And the other comment I have is regarding this Sheffi Paz person, who I was not aware of prior to reading about her in your draft paper. And from what you wrote there, she's done far worse than just spreading hate speech online. She actually went after migrant children to terrorize them. And how is that woman still allowed to run free? I don't understand it.
Yeah. Thank you, Leon, for your first comment. Well, I totally agree. I mean, I don't agree with expanding, legal intervention beyond, as I said, like the imminent danger or violence or other grave breaches of the law. But I think that that what you were saying, I mean, we should address this, and thank you for that. And about Sheffi Paz, yes, I think it's yeah, many people are asking here those questions that you have raised, but you need to understand that according to criminal law, and that's one of the points actually that we were trying to make in our draft, and maybe we should stress it more. Criminal law in Israel, well, basically what she did, breaking into kindergartens of migrant workers or refugees. Well, she didn't physically harm anyone. What she did was she entered them uninvited. She claimed that the gate was open, and so she started shouting slogans and I don't know, taking pictures with her cellular phone, etc. And so courts do not view that as something which is, you should put her under arrest pending trial. So yes, she is running free. And the absurd is, as we also tried to make this point in our paper, is that this brings her more support, because people who identify with her cause see her as a kind of a martyr for those. She succeeds in persuading people that she's being persecuted by the police. And that's why we believe that this action, the criminal enforcement action towards people like Sheffi Paz, is not very efficient, as opposed to civil actions for defamation and breach of privacy and etc., which threaten what we believe is most important for her, fundraising and money. And going after the money, I think in this case is much more efficient in suppressing and curtailing her action.
Thank you.
Thanks. Amna, please. Thank you.
Very briefly, this is really interesting. I share the comments that were made regarding the legal categories we're playing with, the confusion between defamation and hate speech, and the relationship between the hate speech and defamation. The fact that the Israeli law is phrased in a certain way doesn't necessarily mean that all hate speech is by definition also defamation. I mean, courts should be much more precise in allowing civil law suits that are organized differently to either replace or supplement hate speech. That hate speech is a value. Hate speech offends or violates values that the state should be responsible for, and therefore hate speech is a matter for the state to deal with through public law, either criminal law or regulation that represents the public interest rather than individual interest there. So I agree that there is a confusion here in Israeli law. And that also addresses the question of, do we care about the individual or do we care about the group that we're protecting, etc. And also, of course, this also is interlaced with the question of, is it the role of the state or the platforms to do the content moderation? To what extent we care about because your point, Asaf and Efat, is that, we should be really careful when the law intervenes. Question is, so what if do we prefer that the Facebooks of the world will then decide how to deal with it with no due process? And, there are questions there, but my point actually relates to what you just said. And I think the underlying, and I think it corresponds also with what Anna said before. I think part of the decline of the classic liberal model that assumes also a reasonable person out there, it includes also the rise of group-to-group struggle. Because if you view it from the point of view of the haters, they feel oppressed. They feel that they're under attack by the deep state, by those progressive forces that don't care. They don't care, the progressive forces. They don't care anything about the rule of law and fundamental liberty. They are just out there to undermine the culture under siege of those who use hate speech, and it's their form of defending against this oppression, the way they see it. And here, I think that there's a clear, and maybe that could be helpful for our future analytical work, there's a clear distinction between the European model and the US model. The European model suggests, and the Canadian model is part of this, by the way, suggests that, yes, if we look at the psychological damage, or we look at how hate speech silences minorities, we introduce equality or the equal enjoyment of participation in civil society into the equation, then we're fine. The US model says no. The US model basically says, free speech is in public forum, and which is why defamation of individuals is different, because it's outside of public forum. But if it was a defamation of a public figure, the US doctrine says, because we're so heterogeneous, all forms of speech, even very offensive speech, are there, and you reply with speech. You reply to speech with speech, and that's a very different model. So I think the question now becomes, which model should we be inspired by, or maybe a hybrid model, the European model or the US model, when it comes to the situation of we're all minorities, as perceived from the minority. Of course, this is, we can look at the structure of power and say, hey, come on, who has the power? And, Sheffi Paz has a lot of power vis-a-vis the illegal immigrants. Come on, that's clear here. But from the perspective of the Sheffi Pazes, if you silence them, they will experience this as oppression against them, and they will say, okay, you just let go of your underlying commitment to democracy and expression of all viewpoints, etc. So I think this is where it gets to be tricky when you use civil law or criminal law norms to address this. Now, I'm not sure, though, having said all that, I'm not sure that your end test that look for the organization should be the ultimate test. I agree actually with Anna here that sometimes, suppose you're not organized. Suppose this is just one statement, but it comes as part of, even if it's uncoordinated, it comes as a part of a slew of attacks on whatever, Facebook, and everybody says, just like he said, I also think you are whatever it is, dirty Jew, dirty Arab, dirty woman, whatever it is, right? Slander. And there's an accumulation, there's an accumulative effect in a particular context, not just a diffuse, but if in a particular context, you can see the hand, invisible hand, so to speak, of the crowd kind of like descending, then you can also say, even though it's not organized per se, the law should still look at the context. But that's just a comment that you can either agree or not, it's just
Yes, I think I totally agree, Amnon. I think that it's a very, it's a fair comment, and all I can say is, our model purports to address a specific niche within this realm of hate speech, and I agree with all the criticism that you expressed, not only in this comment, but in the beginning of what you said. Yes, of course, this model doesn't have the answers for everything, and of course that when hate speech doesn't qualify as defamation per se, let's say when it's not addressed to a specific person who can sue, then of course our model doesn't work, and it won't, it won't curtail, and it won't deal with the hate speech. So so it's not we don't have an answer for everything. We just think that working within the framework that's already existing in Israel under Israeli law, I think that's an improvement that we can propose. And as to the other thing that you said, it's really interesting. I think that, well, I'm speaking for myself here. I'm not convinced that Efrat will necessarily agree with me, but I think that there is much point in what people like, less Sheffi Paz here in Israel, because it doesn't happen as much here in Israel. But I think that in the United States, you can see it more clearly. Let's take the ultimate example of, Facebook and Twitter, etc., blocking Donald Trump and his supporters. I think that there is much, I can see much point in what they're saying. I think that in a way they are being sometimes silenced. I can understand why it happens. I can understand because we feel, decent people, we feel revulsion. We are repulsed by hate speech. So our instinct is, we don't want that. We don't want expressions like that to contaminate, so to say, our feed, our screen, whatever. So, but I think we should resist this instinct because it's it's really dangerous, and it's not fair, and it goes against everything that we believe in when we talk about freedom of expression. And I think that we had a lot of discussions on that, and I think that one of the advantages that this model has is that it does not discriminate between, extreme expressions from this side of the political map as opposed to the other side. And when it says that, look, we view Sheffi Paz, for that matter, as a member, as a high-ranking member in the hierarchy of an organized group, we also give her a discount when we, so to speak, when we say that when she's publishing hate speech that's directed not against individual asylum seekers or refugees, but rather at other political activists who oppose her opinions, then we say, if they sue you, we are willing to, of course, we will not represent her in court. There are other people that will do that. But as judges, as someone whose job is to enforce the law, we say we're willing to give you a discount. We're willing to say that you will not be obliged to pay compensation, or that the compensation should be reduced, even if the court finds that it is defamation and it doesn't qualify for the defenses, for the other defenses that the law offers, because you published this expression, this hate expression, against people who are organized like you are. And I think that this answers a little bit for the unfairness accusation, so to say, of hate disseminators, etc. And I think that eventually, I think that it gives a model that will be also convenient for courts to apply, because I agree that, theoretically, a scenario like you said, that there is a flow of hate speech that is not directed and not organized, but I'm really having difficulty to see how it could be directed at a specific person. I mean, you could think of a scenario in which, many people, unorganized, are expressing racist opinions against, let's say, Arabs, for example, in Israel. But the chances that it would be directed at a specific, let's say, Arab activist, and not having an organization behind it, I think it's a little bit scarce. And I think that if this happens, I think that more often than not...
Just a quick intervention. Somebody puts a post in Facebook, and then somebody says, hey, look at this post. And then a lot of people come and look, and they say, you're a dirty Arab, get out of Israel, and just people without any organizing...
Okay. So, but please note that our model doesn't give an exemption for people, even if they are not part of an organized group, if they go against someone who is also not a part of an organized group. It might give them, the court might award them with a lesser compensation, oblige them to pay less than if they were a part of an organized group. But in a scenario like you're drawing, this guy who got the victim of the hate speech would be able to file a lawsuit against those commentators separately and get compensated. But he would get less compensation in comparison with the case in which he was suing someone of an organized group. I think this also makes sense. I hope also.
Yes, and I just want to say one sentence. I think we can try to change the word organize and ask questions about power. I think the real question here is power. Who is the stronger actor in the field? That's the most thing I think that we think and speak about it in all of our conversation. Who is the stronger? And another thing I think that we speak about it at the first day, and I just want to clarify that the most of the work here is education. I don't think anybody can think that our position is that the justice system is not a way to go. And I would like to hope that we can educate our children not to talk like that or write like that or think like that. But I'm not sure that I would like people who do not know how to write to be afraid criticizing or writing. And I think it's very important to think about it.
Thank you. We have a very interesting question in the chat from Martin Bergamsmo. Is non-spontaneous hate speech deliverable conduct an act reflective of conscious desire or some other non-mental state category in criminal law, in the presenter's view?
Yeah, okay. I think, yeah, it's really interesting. I must admit, I didn't give it a thought before. I don't know. I mean, yeah, of course it's possible. Okay, yes, it is possible that a comment on social media would be, it's not necessarily spontaneous, but I think that, well, you can say, if we need to characterize expressions on social media, I think it would be roughly correct. It's not our field of research. Of course, it belongs more to social sciences, and it's maybe worthwhile to check into it more deeply. But I do believe that I would say intuitively that when people comment on Facebook or other social media outlets, I think that individuals tend more to, at least on political questions, they tend to comment, as they say, from the stomach, like, they comment something which is more, immediate. Their response, at least that's what our experience in defending people in courts taught us, that they are telling us, well, I wasn't thinking too much. I saw this video of this police officer beating a civilian over COVID regulations, and I just wrote whatever went through my head at that time. And I think that it would be fair to say that people who are part of an organized group, a political organized group, especially like Sheffi Paz and people of that sort, they make a more sophisticated use of social media in order to advance their political causes. So when Sheffi Paz writes a tweet like the one that I showed you before, I don't believe that, it's just Sheffi Paz with her morning coffee or something came across this newspaper bulletin and just, that's what went into went in her head. I think that she looks for opportunities like that in order to advance her agenda. And I think that it's if spontaneous versus deliberate is put on a scale, I think that it tends much more to the deliberate extreme than to the spontaneous. And what we look for is to defend spontaneity, as I said, the right to be spontaneous. But of course, it's not perfect. It's never perfect, and the legal system works on legal truths, so to say, as much as you can prove in court with evidence, and not always you have evidence. And at the end of the day, it's the judge that adjudicates the case, and she has to decide whether it's defamation, whether it has, it's entitled to the defenses or protections of the law or not. And sometimes, it's never perfect. So yeah, but it's the best that we can offer, I think.
Thank you. Martin, please.
Thank you. Yeah, so we're running out of time. I just keep it short. I would have to say a lot of things. I liked your presentation, Asaf and Efrat, because I used your argument several times here as well. This argument that it may not enough to just focus on single statements in judging about such cases, but to regard the larger context. But maybe, and I just add my personal my perspective as a social scientist to that. There may be a tension between dealing with single cases and this macro perspective on how we organize debate in society. For when we define hate speech, for example, our perspective as communication scholars is that the term part speech denotes public statements, and that is something different than the case you mentioned in your lawsuit, which at the beginning was just an interpersonal communication situation. And the question is a little bit that's what I learned from this discussion here, how to bring together decisions about such a single case on one hand and general rules we make out of them, because in the end we might end up with what Amnon referred to, that you always can say in this single case the person may just have a restricted code to express his feelings, but we in society we very quickly then will have strategic actors who will just pretend that they need to express in a certain way, and then and express publicly a lot of hate that goes beyond, and that you cannot judge like a single case as you did it in court. So that is an interesting, I think, even particularly in our group here, that's one of the major problem fields to combine clear rules for assessing single cases and finding general rules for society when it comes to hate speech.
Yes, thank you, Martin. That's a very interesting point. I think that yes, we as lawyers, as litigators in a system which is structured as roughly speaking as common law system, you have to start from the bottom up. You have to litigate those cases as we do in the lower tribunals, and then if you lose or the other party loses and appeals, you work your way up the system. And then when higher tribunals decide the cases, you need to hope that they will decide the principal questions and not suffice themselves with deciding the case-by-case issues, the specific issues, so to speak, as it often happens. But sometimes we are successful in persuading courts to address more general questions, and I think that this can answer maybe for the structural aspect of your question, I think. But well, I'm aware of that it's not a perfect solution, and of course there is always a way out of the rules that courts and for that matter also for the legislature sets, and of course I can't say that it would be impossible for people like like Sheffi Paz or other members of hate groups to disguise themselves as private persons who are just, speaking out their minds. But it would place a burden on them. They would have to, just for an example, they would have to open different accounts. They would have to, disguise their identity. And I think that social media, as it is structured, doesn't make life easy for you in that sense, because let's say that you, as Martin Emmer, you have your Facebook account and your Twitter account, and you have your followers and you have your friends. And if you publish a comment, then you want all your friends and followers, etc., to be exposed to that naturally, I think. And if you, let's say, open a false account in order to disguise your identity as a group member, then what happens is you lose this exposure. And that's just to give one example. And what I think what we are trying to do, it's a never-ending game between let's say the people, the haters, the hate speech disseminators, and the good guys, so to say, that try to regulate this this arena. And I think that what we can hope for is making life more difficult for them, placing larger burdens on them, and enhancing the costs and the difficulties that they face if they want to keep disseminating those hate messages. But you will never stop them. You will never end this phenomena of hate speech. I think one of the presentations yesterday, there was a great image of an interviewee in one of the researchers that said, you'll never end this. It's like a war. There will never be an end to wars. But what you can aspire for is, to regulate this and make it a little less, make life hard on them. And I think that's what we are hoping for.
Thank you, Asaf. There is one comment from Anne following, I think, Efrat comment. The justice system sends signals. There's something like expressive law. If you want to comment on that.
It was maybe I can quickly clarify. I just meant to say that was an answer to Efrat's remark that it's education is very important, and I agree. But I think the role of the law should not be underestimated in that it sends signals of what is the right thing to do. So there is an expressive function of, and there then we differ, whether it should be civil and certainly even more forceful with criminal law. That's all I wanted to say.
Yeah, I agree.
Yeah. Thanks. We came to the end of this session. I think it's a very interesting discussion, and the model you are proposing, I strongly believe that it's provide tools at least to the, as you said, not to stop the war, but try to defeat or win in some cases in that regard. I really enjoyed reading the draft, looking forward to the final version and the discussion, hopefully that enrich you and give you some thoughts to how to proceed. Thank you, Efrat. Thank you, Asaf. It's really interesting. And Ido is in charge again. Thanks. Have a lovely enjoy the rest of the day.
Thank you, Adil.
When do we restart?
Yeah. That's one of my roles here, apparently. We're going to take a short break for 15 minutes. We're going to reconvene in 10:35 European time. Yeah, so enjoy your break.
Thank you, Ido.